El tema en concreto es analizar las consecuencias de tener dichos depósitos o inversiones los mexicanos en los Estados Unidos y en paraísos fiscales. Partamos de la premisa de que tener dinero no es delito. El problema, la ilicitud, surge cuando este dinero no ha pagado contribuciones, impuestos, o bien porque provenga de actividades ilícitas, o bien ambas, que sean producto de actividades ilícitas y que adicionalmente no hayan pagado impuestos. Esto nos llega a formular las siguientes preguntas. Y lógico es preguntarse si los recursos ilícitos que provengan de actividades ilícitas, de delitos, deben de pagar impuestos. Y la respuesta es sí. Sí, al menos en México, porque incrementan el patrimonio. Y esto parte de un principio que ya desde hace muchos siglos, incluso los romanos decían que el dinero no huele y por lo mismo deben de gravarse cualquier tipo de actividad, incluso las ilícitas, sobre todo por el impuesto sobre la renta, más no el impuesto al valor agregado, que obvio es no puede gravar actividades ilícitas. La otra pregunta que nos tendríamos que formular es que si el dinero que no paga impuestos también es considerado como ilícito. Es decir, si el dentista, el abogado, el arquitecto que tiene ingresos en México y los deposita en una cuenta bancaria en México, en Estados Unidos, para este público, puede constituir el delito de lavado de dinero. Hay diferentes posturas. Sin embargo, en nuestro país, en México, sí lo es. Es decir, sí se puede considerar lavado de dinero el producto de actividades profesionales que no han cubierto sus contribuciones. Es así que el análisis de cualquier depósito bancario para fincar una responsabilidad penal debe analizarse a la luz de dos principios. Primero, la licitud o ilicitud de los recursos y segundo, si estos recursos han pagado contribuciones. Y esto a su vez nos lleva a preguntarnos si se pueden perseguir simultáneamente los delitos de defraudación. ¿Me escuchan? Si los delitos de defraudación fiscal por la omisión del pago de contribuciones se pueden perseguir simultáneamente con el delito de lavado de dinero. Sin embargo, antes de entrar a este tema, quisiera anticiparme respecto de la forma en que pueden investigarse este tipo de delitos. Si bien decíamos que el tener dinero no es ilícito, también es cierto que la ruta del dinero siempre deja una huella muy clara para la investigación de cualquier delito de contenido económico, ya sea lavado de dinero, defraudación fiscal o delitos incluso relacionados con casos de corrupción. Hay un mito o una reminiscencia histórica, seguida incluso de manera familiar, de muchos mexicanos o latinoamericanos que han pensado que tener depósitos en los Estados Unidos impide a sus respectivos gobiernos, en el caso nuestro, al gobierno mexicano, tener acceso a su información financiera para iniciar investigaciones en su contra. Y sí, es común que mexicanos tengan depósitos en Estados Unidos que constituyan estructuras, fideicomisos, empresas, que no solamente tienen cuentas en los Estados Unidos, pero adicionalmente sus domicilios fiscales en paraísos fiscales que, como veremos más adelante, tienen otras consecuencias adicionales a la omisión del pago de las contribuciones. Es por eso que la pregunta en concreto es si el gobierno mexicano puede tener acceso a las cuentas bancarias de los mexicanos en los Estados Unidos. En primera instancia, desde el punto de vista fiscal, podrán ustedes pensar en el FATCA. No lo abordaré porque más adelante mis compañeros harán referencia a puesto que hay casos en los que dicho tratado entre México y Estados Unidos no aplica. Ahora bien, fuera del FATCA, el gobierno mexicano sí puede tener información de los mexicanos con cuentas en el extranjero y en concreto en Estados Unidos. Para esto, me gustaría hacer una división del tipo de asuntos que pueden llegarse a investigar con motivo de dichos depósitos. En primer lugar, por lo que se refiere a la materia fiscal, debemos recordar que en México el Servicio de Administración Tributaria es quien revisa el cumplimiento de las obligaciones fiscales de los contribuyentes y puede pedir información financiera tanto en México como en Estados Unidos durante el ejercicio de sus facultades de comprobación en base a un convenio de intercambio que tienen ambos gobiernos y en estos casos, los fiscalistas lo saben bien, al pedir información el SAT al IRS en Estados Unidos, la visita domiciliaria se duplica, es decir, de 1 año se amplía a 2 años la revisión. Y en el caso de que el SAT encuentre irregularidades por depósitos bancarios, incluso en el extranjero, será posible que se presente una querella ante la Fiscalía General de la República por delitos de carácter fiscal. Y ustedes dirán, teniendo dinero en Estados Unidos, un mexicano, ¿qué delitos me podrían imputar por no pagar las contribuciones? Los delitos más comunes, derivados de la detección de depósitos bancarios, consisten en omitir declarar ingresos acumulables o declarar ingresos acumulables menores a los realmente obtenidos, o bien no presentar declaraciones y adicionalmente dejar de pagar contribuciones por las mismas. Esto se encuentra tipificado en el artículo 109 del Código Fiscal de la Federación. Sin embargo, creo que la mayoría de las personas han dejado pasar una disposición muy concreta que desde hace varios años está vigente en la Ley del Impuesto sobre la Renta y que se sanciona en el Código Fiscal. Debemos recordar que aquellas personas que tengan depósitos, cuentas, inversiones en paraísos fiscales que generen rendimientos, tienen la obligación de presentar una declaración informativa ante el Servicio de Administración Tributaria en el mes de febrero de cada año. En caso de que no se cumpla con la presentación de este informe, se incurrirá en un delito previsto en el artículo 111, fracción quinta del Código Fiscal de la Federación, que da lugar a la imposición de una pena que va de 3 meses a 3 años de prisión. Por lo mismo, esto nos lleva a concluir que no solamente el dejar de pagar impuestos constituye delito, sino también el tener depósitos, inversiones en paraísos fiscales, llamados jurídicamente, en términos de la legislación mexicana, regímenes fiscales preferentes. Si no se da aviso de esto, también se incurre en una responsabilidad de carácter penal. Ahora bien, por lo que se refiere a la ilicitud o el origen de los recursos, la consecuencia de tener depósitos por derivados de actividades que pudieran considerarse ilícitas o que provengan de actos de corrupción, esto se integra el delito de lo que es comúnmente conocido como lavado de dinero y sancionado en México en el artículo 400 bis. Estos delitos, como ustedes saben, le corresponde investigarlos a la Unidad de Inteligencia Financiera, que es la homóloga del FinCEN en los Estados Unidos. Ambas instituciones, el FinCEN en Estados Unidos y la UIF en México, tienen un intercambio permanente de información, de tal manera que la UIF cuenta con información suficiente de todos los contribuyentes respecto a actos que hayan sido actos o depósitos reportados por el FinCEN a su homóloga mexicana. Sin embargo, también la UIF, la Unidad de Inteligencia Financiera en México, tiene acceso a información a través de un mecanismo, a través del grupo Egmont, en el que participan todas las unidades de inteligencia financiera y en el que se puede intercambiar información en tiempo real de cualquier persona de cualquier país. Ahora bien, esta información que recaba la Unidad de Inteligencia Financiera para presentar una querella ante la Fiscalía General de la República, debemos tener en cuenta que no puede usarse en juicio. Para que se pueda utilizar en juicio esta información, será necesario que el Ministerio Público pida la misma información proporcionada por la UIF o por el FinCEN a través de los mecanismos correspondientes, que en el caso de México sería a las instituciones bancarias con autorización judicial, pero en el caso de depósitos en el extranjero existe un tratado de cooperación sobre asistencia jurídica mutua entre los Estados Unidos de América y México, en base al cual el Departamento de Justicia en los Estados Unidos y la Fiscalía General de la República en México pueden solicitarse recíprocamente información financiera de cualquier persona para investigar ilícitos de cualquier tipo. Luego, entonces, fuera del FATCA, insisto, fuera de del aspecto netamente fiscal, también la Fiscalía General de la República puede solicitar información financiera a los Estados Unidos en base al tratado al que he hecho referencia. Y de la misma forma, la Fiscalía General de la República tiene también la misma posibilidad de aplicar este tratado para solicitar información de los mexicanos en Estados Unidos en base al tratado al que he hecho referencia, con independencia de si son delitos de carácter fiscal, lavado de dinero, pueden ser hechos de corrupción, en fin, no hay un límite, solo que se cumplan con las formalidades del tratado y que la información solicitada se utilice para los procedimientos instaurados por las fiscalías. Ahora bien, ustedes se preguntarán, un tema, no lo podemos dejar de abordar, los Pandora Papers, ¿sí? Pandora Papers es, la verdad, una mina de oro para los gobiernos de todos los países, porque a través de estos ya tienen los indicios suficientes para iniciar investigaciones en contra de las personas que han aparecido en estas revelaciones periodísticas, puesto que podrán solicitarse información de personas que han omitido el pago de contribuciones, lavado de dinero o bien que han sido producto de actos de corrupción por servidores públicos. Pero en este caso, ustedes se preguntarán, ¿quién va a investigar esto? Dicen, bueno, en principio el gobierno mexicano, claro, porque tiene facultades y porque son hechos cuyo origen se remonta al territorio nacional. Sin embargo, les tengo malas noticias para algunas personas, porque como dirán mis colegas a quien me honra acompañar en esta mesa, abordarán este tema en el que ustedes podrán advertir que ahora el gobierno americano podrá investigar a aquellos mexicanos con cuentas en el extranjero, en Estados Unidos, que no hayan pagado impuestos. Y esto es muy importante porque podrán pensar en que hay una aplicación extraterritorial por parte del gobierno americano en contra de los mexicanos con recursos en bancos estadounidenses. Sin embargo, debemos tener en cuenta que son acciones que han sido reconocidas ya por las autoridades americanas y que nos llevan a la conclusión, o bueno, a emitir una recomendación muy importante para todas aquellas personas que se encuentren en este supuesto. Regularícense, una regularización, pago espontáneo de contribuciones. ¿A qué nos lleva el pago espontáneo de contribuciones? Si el contribuyente en México, contribuyente mexicano, paga espontáneamente, es decir, antes de que lo descubra o que le inicie una revisión la autoridad fiscal, impedirá que se le inicie un procedimiento penal. Es decir, pagar espontáneamente sus contribuciones impide el ejercicio de la acción penal e el inicio de un proceso penal por delitos de orden fiscal. Sin embargo, ante la falta de regularización por parte de los mexicanos que se encuentren en este supuesto, estarán expuestos no solamente a acciones penales por parte del gobierno mexicano, sino ahora también por parte del gobierno americano, teniendo en cuenta que los plazos de prescripción de los delitos fiscales en México y en Estados Unidos desde el año 2011 son diferentes. Hasta 2011 en México la prescripción y la facultad para que la autoridad fiscal presentara una querella empezaba a correr a partir de que ésta tenía conocimiento. Sin embargo, a partir del año de 2011, la prescripción empieza a correr a partir de que se consuma el delito. Es decir, una vez que se presenta la declaración o se deja de presentar la declaración, se consuma el delito, hay 5 años para que la autoridad fiscal presente la querella correspondiente. Sin embargo, en Estados Unidos se sigue el criterio que teníamos nosotros en el pasado. La prescripción empezará a correr hasta que la autoridad fiscal en los Estados Unidos tenga conocimiento del ilícito, es decir, el plazo de prescripción para la investigación de delitos fiscales en los Estados Unidos respecto de cuentas de mexicanos será mayor al que tienen en México.
Excelente, Ambrosio. Bueno, yo creo que es el momento de conectar esta explicación del lado mexicano de las leyes mexicanas con las leyes americanas, ¿no? Enfocando en este escenario que estás discutiendo de mexicanos con recursos del lado americano. Aquí obviamente pensando en instituciones financieras americanos que abrió muchos ojos a estas noticias de los Pandora Papers, por supuesto. Y con esto tenemos expertos, super expertos del lado americano, quien van a explicar a todos nosotros los herramientas que tienen del lado americano por la ley americana, no solo lo fiscal. So with that, we're going to go, I think, directly to Mr. Kevin Sweeney, who I think you've been in private practice. You left about 2016, am I guessing correctly?
16, so yeah, I've been in private practice about 5 years.
Right, so you view the world a little bit different now, maybe on the private practice side than you did when you were at the government. But you had the opportunity to work, of course, in cross-border international cases, mostly outbound focused. Outbound meaning U.S. taxpayers with assets, say overseas. We had the big Swiss bank scandal that was, we're not going to go into here, but that had a sea change, I would believe, in how laws like FATCA came into place to identify accounts and assets. That was really transparency laws, is how I like to think of them, not really tax laws per se, but it was just to force the identification and various means of reporting accounts and assets internationally. So why don't you tell us a little bit, what are the key tools that you see and that the government uses in investigation, like we had discussed previously, for the benefit of our audience?
Sure. Well, I mean, the primary tool in any investigation is whatever document that can compel someone else to either produce documents or testimony. And I say that generally and broadly because it depends on what type of crimes you are investigating. For instance, when you're investigating U.S. tax crimes, there's 2 ways that you can do that investigation. One of that way is to do an administrative investigation. And the way that investigators get information in those investigations is through the summons process. And a summons, for those of you who practice more civilly, is sort of like an IDR. The difference is it can be enforced in a court. It's not self-enforcing, but it can be enforced. The summons process has some drawbacks, and the administrative investigations sometimes have some drawbacks that other types of investigations don't. And those are that when an investigator sends a summons requesting either documents or testimony from particular people, sometimes they need to provide notice to the person who's under investigation. And a lot of times investigators don't necessarily want that, or they want to time that for a period where it works in their investigation. And so when it comes to a point where that doesn't work for them, the other way that they can investigate that something is through a grand jury investigation. Okay, and that type of investigation can be used not just for U.S. tax crimes, but for pretty much any crime. And one of the things that we've been talking here today, and we're gonna talk about, is not just sort of what we hear in the news about the U.S. going after their own U.S. citizens and residents and trying to find bank accounts and undeclared assets, right? But there's another category of prosecutions where we've seen a little bit less so far. There's been few cases, but based on the Pandora Papers and the fact that the international community, I think, is concerned about their citizens and their residents moving and hiding money in the U.S. For those types of investigations, the inbound investigations, where the goal is to essentially prosecute people for violating foreign tax laws and possibly even getting money back to those cases are done through a grand jury investigation. So it wouldn't be done the way, with an administrative investigation.
And when we talk about summons, that's a statutory regime to collect information, and especially like from third parties. But it's a powerful tool that we've learned because there's not just sort of the run-of-the-mill summons that you identify a particular third party and say, Bank X or Company Y, I need this information as part of my investigation. The John Doe summons is really a powerful tool that I think Joshua Smelter can explain, because he was a key attorney involved in that process of how the Department of Justice used John Doe summonses on behalf of foreign countries requesting information here in the U.S. outside of FATCA, as Ambrosio Michel was talking about, and also how John Doe summonses have been used successfully, as we know, because the Supreme Court recently rejected cert on the Taylor Lohmeyer firm, how John Doe summonses can be issued directly to even law firms in the United States, which was the case in the Fifth Circuit. So can you give us, help us understand how that summons power works and how the government uses it? And of course, you were a key person when that was happening before you left the government in 2019, even more recently than Mr. Sweeney.
Yeah, I don't think a lot of taxpayers recognize the John Doe summons, but it is gaining popularity. You see it in the news more often because, so with the Swiss bank account, when that came out, they knew there was a problem, but they didn't know everybody that was there. And that's exactly what the John Doe summons is designed to do. And now what Kevin was talking about, you can do an administrative summons, and that doesn't require any court interaction unless someone doesn't comply. And then you can petition the court to enforce that summons. John Doe summons is a little different. Because you don't yet know who the people are, the government is required to get permission before they even issue that John Doe summons. And even the internal rules of both the IRS and the DOJ require approval at literally the highest levels before they can even ask a court to do so. Putting my government hat back on from a few years ago when I was there, area counsel at IRS would have to approve it, and then they would make a request of the Deputy Attorney General for tax in Washington, D.C. They would approve it before I, as a DOJ attorney, could file the petition in district court in order to ask just that the summons be issued. They're not a new thing. The government has used them before domestically to go for tax shelter promoters to get the names of the people who had participated in transactions that the government disagreed with. And they used them with the Swiss bank accounts when they had that problem. And then when I was there, the United States has had a lot of success in asking foreign governments for accounts that were in foreign jurisdictions and the money was being drawn out via credit cards at ATMs within their own home country. When the other countries, when they found out about these programs, wanted to do the same. And so what they would do is they would use their treaty to make a request that the Department of Justice ask a court to allow them to serve a summons on a bank in order to get the names of the people for account numbers where they had found activity that they thought might be someone violating the tax rules. It basically has 3 requirements in order to be able to do those that the government has to meet. And they have to prove that there's an ascertainable group of people or an individual. And then they have to prove that they have a reasonable basis to believe that the internal revenue laws are being violated. And for purposes of internal revenue laws, the Fifth Circuit and other circuits and other cases have said that that international treaty makes the violation of foreign internal revenue laws part of the laws that can form that reasonable basis to be able to do it. And then after that, it has to not be publicly available to otherwise. All of those proceedings are done ex parte, which basically means that neither the bank nor any of its customers whose names might be turned over participates. The court makes that ruling with just affidavits and other things that the government produces explaining why they think they've met those factors there.
And can you tell us which countries, I mean, obviously it's not private information, it's public information, but which countries when you were there had made those sort of requests to the U.S. government for these broad John Doe summons in the United States?
Yes, so most recently I think Finland had, and then I also worked on one for the country of Norway and also the Netherlands that way. But any country with a treaty, Mexico included, has a Information Exchange Act that's part of their convention and their treaty, can make that request to the government if they have that. The way that it's done is the competent authorities for both countries will discuss, and then they will try and make sure that they meet those requirements in order to be able to issue it to the court and meet the standard that they need to.
Y este tema es tan importante que quiero explicar muy brevemente en español. Seguramente capturaron ustedes la explicación en inglés traducido a español, pero por los conceptos técnicos, el concepto no existe en México, que este concepto de la ley americana que se llama el John Doe Summons, cuando un país está pidiendo la información, porque que no entramos mucho en el detalle de FATCA, como mucha información en bancos aquí no está compartido automáticamente con México o otros países, porque por las reglas no está excluido por el intercambio de información. So, ¿qué puede hacer un gobierno para encontrar la información en los bancos en los Estados Unidos o despachos o contadores, abogados? ¿Qué puede hacer? Puede hacer este tipo de proceso a través de un John Doe Summons, donde dice, quiero saber todo, en el caso de Finlandia, todas las cuentas y la actividad de este grupo de personas contribuyentes en Finlandia, por ejemplo, en Finlandia, en el sector financiero, por ejemplo, en los Estados Unidos. Hasta el momento, México no ha provocado este proceso, este mecanismo. Creo que es poco conocido. Ese es algo muy novedoso en los últimos años. Hasta la fecha, no solamente Dinamarca, Finlandia y y Noriega pidieron esta información. Yo estoy convencido, es cuestión de tiempo, de cuando empieza pidiendo México este mismo tipo de información a través de este proceso de un John Doe Summons. Y este es una ley muy poderosa porque en el circuito donde está Texas, un despacho de abogados fiscalistas y hoy en día ya tiene que compartir toda la información al gobierno americano de sus clientes, sus fideicomisos, sus sociedades, offshore, cuentas, todo desde los años 90. En este caso de Taylor Lohmeyer, que llegó hasta el Fifth Circuit y negó el despacho sus argumentos que está privilegiado, ya negó estos argumentos, llegó hasta la Corte Suprema de los Estados Unidos y hace unas semanas tampoco tomó este caso. Ya es la ley, por lo menos completamente en este circuito que tenemos Texas en el Fifth Circuit, no California, pero tenemos Louisiana, Alabama. ¿Qué otros estados en el Fifth Circuit que tenemos? Oklahoma.
Yeah.
Oklahoma, creo que son estos estados. Bueno, pero en California estamos en la 9ª circuito. En la 9ª, hace unas semanas, hay otro caso en los Estados Unidos, el Grand Jury, donde ya decidió el corte en el 9th Circuit que las comunicaciones entre fiscalistas y sus clientes, abogados, no está privilegiado por la forma y la manera de la comunicación, que es muy amplio. El punto es, hay muy poca, en mi opinión, privilegios entre abogados y clientes como antes existía. Tan importante para enfatizar el John Doe Summons, esta facultad. And Daniel Silva, I know the John Doe summonses, that's something that's used, of course, under Title 26. That's not a power that's used from your perspective, but maybe, Joshua, can you explain a little bit about that FATCA loophole and how that ties into then collecting information in the United States?
Sure. So the United States created FATCA basically because what they had realized was that individuals were setting up entities that were essentially just shells, and they were using those entities as essentially the official customer of the banks. And they could not, at that time, they didn't have a mechanism for looking through those entities to find out who the true beneficial owner, which is now a term of art, of those accounts were. And so they created FATCA to do so. And as FATCA is written, a foreign financial institution must look through those entities that are set up in order to find out who the true beneficial owner behind those entities are. The problem is that it's not reciprocal for U.S. financial institutions to look through foreign entities to beneficial owners. That is the loophole, which kind of allows this shield that less than reputable people are now using to essentially still hide. Now, secrecy is very, very valuable. And we've known that from the history of tax evasion, that it's very, very valuable. So as long as there's a way that secrecy can somehow exist, people sell it, and they have been. But through the John Doe summons, it's not automatically reported, but that does not mean that it's not available, because the government could still ask the U.S. to send a John Doe summons, and then that information, to the extent it exists within that bank or with the attorney that helped them or the accountant that helped them, those privileges between the two, attorneys and accountants, is whittling away, because what I think the government has learned is that they put all these burdens on the banks to keep information, turn over information, and do that. And so people then moved to attorneys, believing that attorney-client privilege and accountants, which also have their own privilege, might be able to shield it further and put another stopgap in there. But that's the FATCA loophole that is there. There is a way around it. It's just more cumbersome than automatic reporting would be.
And so I think that's a good segue for Danielle Silva to give us a little background here at the U.S. Attorney's Office, the work you deal with in cross-border financial crimes. Obviously, it's more than just Mexico, but this division was funded by the Internal Revenue Service, and it'd be great to explain how your team of investigators, the expertise they have, because those of us who used to work for the IRS or have maybe accounting backgrounds, we view the world, I think, a little differently as to how numbers work and how financial information can be studied and analyzed. And maybe you can talk about how that ties to what your office does at the U.S. Attorney's Office and your investigation team.
Sure. Buenos dias. That's the end of my Spanish portion of my presentation. Thank you for inviting me here. I represent the United States Attorney for the Southern District of California, which means the entire southern border of California with Mexico. Any crime that happens there that is a violation of federal law gets prosecuted by our office. So I work for the Department of Justice, but I work alongside all of the other criminal investigative agencies that the United States has. If you're from Mexico, you may not be very familiar with them, but if you've watched any movies, you surely will have heard of the FBI, the DEA, Homeland Security investigations, and one that almost no one in America even knows about, IRS-CI. What that means is IRS has a criminal investigation wing, and they can do effectively the same thing that FBI, DEA, and HSI can do. The difference is, as Patrick mentioned, they're accountants with badges and guns. And they are clearly focused on tax crimes, but more importantly, they're focused on financial crimes. Here along the southwest border with Mexico, you can imagine there are a lot of financial crimes involving cross-border transactions. And there are also a lot of individuals and professionals, sad to say, based throughout Latin America who conduct transactions at our border with California. And we are here, the U.S. Attorney's Office is here, to investigate and prosecute those crimes. As Patrick mentioned, about 10 years ago when I started at the U.S. Attorney's Office, the IRS said, we need to develop a task force. What that means is IRS, the criminal wing of IRS, teamed up with other federal agencies like DEA, FBI, HSI, Secret Service, as well as state and local criminal investigative agencies. The big local law enforcement agency here in San Diego is the San Diego Police Department. Pretty basic. From California, we have had another criminal agent from the California Franchise Tax Board, which is functionally California's taxing authority. And what the intention of the task force is to combine all the resources of all the various agencies to do an extraordinary amount of hard work and then let me take all the credit. I get to come to these cool conferences. I get to present the case in front of the judge and the jury. I get to present to my office when it's time to indict a person or a business, or even more, seize their money. What that means is if property is involved in the various crimes that we investigate, we can take that money. We can forfeit that money. Forfeit being a fancy word for, instead of it being the criminal's money, it's now the United States government's money. And then there's also returning funds to victims. When we are investigating crimes, one of the things we look for is what drives, what motivates the criminal or their associates. When we initially started the task force, there was an enormous amount of US dollars flowing north from Mexico into the United States. As we developed our cases, as we continued to seize money and other assets, as we continued to prosecute individuals and businesses, we learned that there were really two large motivators. One, drugs. There was an enormous controlled substance money laundering problem here in San Diego and throughout Latin America. But the second one that we have continued to develop was tax evasion. But the tax evasion, strangely, or maybe unpredictably for us, the individuals were bringing money north and the businesses were sending wires north, not necessarily or initially to evade US taxes, but to avoid Mexican taxes. And so these are VAT taxes, personal income taxes, other excise duties that Mexico imposes on businesses and individuals. And what we've seen more and more is that there are individuals and businesses, whether it's because of the FATCA loophole or simply because they think the Americans are only concerned about ensuring that the Treasury gets its money, the money that was defrauding the Mexican government or state governments or failing to pay their share of taxes, it was making its way here to the United States. What we are able to do is we are able to use something a little bit more obligatory, is probably the word, than a John Doe summons. In criminal law, we don't summons people, we subpoena people, which is basically a court order to appear somewhere, provide testimony, and provide records. The most significant amount of records that we obtain are from US financial institutions. These are not only transactional records, but they're the anti-money laundering, know your customer, background on the account holders that banks have to acquire in order to open the bank accounts. And we find an enormous amount of information from all of those records. In addition to that, as any of those who traveled internationally to this conference or previously know, when you leave or enter the United States, whether at the San Ysidro port of entry, on a plane, a cruise ship, you're often given a form that says, if you have more than $10,000 in cash, there's nothing illegal about that. You just have to fill out this form. Well, you might be surprised, of course, no one here is, but if you were an international narcotics money laundering organization, you may not want to declare your millions of dollars in cash that were derived from cocaine or methamphetamine sales. You don't often put that on those forms. The United States, in all its wisdom, has said that's a crime. If you knowingly and intentionally fail to report your bringing in or taking out more than $10,000 in cash, we can prosecute you. And so that was the very first type of crime that our task force looked into, was people simply moving money in enormous amounts with the intent to not disclose that. Because of course, if you are law-abiding, if you aren't evading taxes, either on this side or that side of the border, you'll hopefully be transparent. As we've moved along, IRS, CI, and our task force partners, we've begun to look more and more at international money laundering and international wire fraud. What that basically means is if an individual or a professional, sad to say, agree to deceive or defraud anyone, anywhere in the world, including the Mexican government, of their due property rights of taxes, getting paid whatever they are owed, if that touches the United States, and by touches I mean you send one wire transfer of funds from a Mexican financial institution to a US financial institution, if there's one phone call from Mexico to an individual in the United States, text message, email, YouTube video, anything that touches or we can access or took place here in the United States, that now gives the US law enforcement apparatus the ability and jurisdiction to prosecute you or your clients or someone you may know for wire fraud.
And that's such a unique concept for many of us that are tax professionals to understand that. Help, because right now we're not talking about a violation of U.S. federal tax like evasion, Title 26, what Mr. Sweeney was referring to, that you were dealing with. That's not in the cards. It's not U.S. violations of the U.S. tax laws. You're now invoking this wire fraud concept, which is for those of us that are tax geeks, we're like, wait, what do you mean wire fraud? And how you're explaining that, help us understand that in light of the Supreme Court's decision in Pasquantino, which said defrauding foreign governments of taxes with this activity, which just make sure we understand it. You said emails, phone calls, I think facsimile. Nobody uses facsimile anymore, but YouTube, yeah, social media. I guess all of that help us understand how is that problematic. You are obviously explaining that, but help us tax professionals understand that, Danielle.
Sure. So the Pasquantino case was not my investigation. This took place, I believe, in New York, and it involved a group of individuals who really didn't want to pay the taxes that Canada would demand upon importing liquor from the United States into Canada. Now, I know everyone here hates to pay their taxes on liquor, but when you conspire, basically when you come to an agreement with someone else with the intent to deceive or to defraud someone else, that is fraud. What makes it a federal felony in the United States with a maximum prison sentence of 20 years is when you conspire and you agree to deprive someone of their right to property in a deceptive way. And so what these individuals did was they would buy a whole bunch of alcohol here in the United States in certain places where taxes were really low, and then smuggle them into Canada and declare that they were not importing any alcohol or anything else, which was a lie, or as we call it, fraud. They had coordinated the fraud through phone calls, text messages, emails, and the entire purpose of the fraud, there was no dispute about it. The entire focus was to deprive Canada of income, to deprive Canada of its right to have its taxes collected. The case went all the way to the United States Supreme Court, and the Supreme Court said, our interest here in the United States is not necessarily to make sure that Canada collects all its taxes. While that's a nice side benefit, we in the United States have an interest to ensure that our wire facilities, our phone companies, our internet, our communications networks are not used to facilitate fraud, no matter who the victim is, which is a really important point because there's now global frauds. So I have a case right now where it involves cryptocurrency, where the individual was promoting deceptive statements, concealing how much money he and the group was making. But the centerpiece of the fraud was in India. But they were globally promoting their fraud. And so there's victims all over the world. In the same way that in Pasquantino, the Supreme Court said, we don't want our phones or internet or our banks even being used to defraud foreign governments, in the same way we don't want our internet being used to defraud a global population. And that if you or other persons who have agreed to conduct the fraud in a conspiracy, if you are involved in using anything in the United States to carry out that fraud, that makes it a U.S. crime. So the most extreme example and hypothetical for the individuals in this room would be if they had clients in Mexico. Let's say there's 5 clients who conspire and agree with you or other people or themselves to conduct thousands of transactions in Mexico with the single overriding purpose to prevent Mexico from collecting its taxes. And at the very end of all of those transactions, let's say it was successful and all the tax in Mexico was not paid. Upon wiring that money into the United States, the proceeds of that fraud, or of making a phone call to another professional or to a bank here in the United States so that we could send the funds up here, that then makes it a U.S. criminal issue, which could result in charges for wire fraud, international money laundering, possibly tax evasion here in the United States, and a whole raft of other crimes that are involved. More than that, and then I'll pause. Even more than that, if you sent the money up here, let's say it was $1 million, that $1 million would be considered proceeds of the fraud in Mexico. So basically, your agreement to defraud Mexico resulted in $1 million windfall that should have gone to Mexico. Those are the proceeds. That's the result of the fraud. When those proceeds make it to a United States financial institution, we in the federal government, and I'm sure state governments, but the federal government can seize those funds and say, these are now proceeds of fraud, and you, the co-conspirators, will never get this money back. And if anyone is going to get the money other than the United States government, it's most likely going to be the victim of the fraud. In this hypothetical, it would be the Mexican government. So again, you can see how the United States government in that hypothetical doesn't want our banks to be the repository of global frauds, of global crime, and the interest is to ensure that our banking system and our communications facilities are used for good purposes, lawful purposes, and are not used to stash, hide, or conceal the proceeds of fraud against foreign individuals or foreign governments.
And we'll get back to that forfeiture power that you were referring to. But can we jump over maybe to Joshua to talk about how that ties together with what you saw while you were at the government, and then the most recent indictment of an international tax professional in our state of Texas. Why don't you tie that together as to the interest of the federal government in international transactions?
Sure. So as Daniel said, the IRS is no different as well. The Commissioner of Internal Revenue has gone on record several times. The head of the DOJ tax division has gone on record several times that they don't want our financial institutions, and they're not willing to tolerate any tax evasion, even if it isn't against us. So I think that's definitely true. But there's also this concept, which I think we're at the beginning of it, but it's going to become a bigger issue as we go forward, is this concept of people who enable the tax evasion. They're the people who are the actual crime and they're co-conspirators, but sometimes that co-conspirator is a professional that they've hired that helps them, it enables them in order to perpetrate this fraud. And unfortunately, back in Texas again, there was a recent indictment of a tax attorney who had helped a couple of individuals who are now the largest tax evasion cases, I think, that have been brought in history. He had enabled them to use several offshore companies in order to avoid taxes, and they were all over. Now, this was outbound again, but with the Pasquantino case, I think that it's not that hard of a leap to make that inbound. Whereas if there are tax attorneys that are helping foreign nationals use the US as a tax evasion mechanism, I think all the quotes from the government are saying that they are not going to tolerate that, and they would do the same as they are with these outbound indictments.
And this indictment you referred to is Carlos Kepke in the Eastern District of Texas.
So he's got Eastern District, I think he's got a couple other districts, and I think one in California now.
Okay. So he's a popular guy with the federal government.
Yes.
But infamous and a long-term international tax lawyer, but frankly, many decades. I know many of his peers at his age. I mean, he's not a young guy. I think he's well into his 70s. So now it's a powerful point, because I think a lot of people just don't think, well, these are foreign laws. So if foreign laws are violated, I'm a U.S. licensed lawyer. Why should I be concerned? That's foreign law. I shouldn't be concerned. But when you get to the powers of your office, Daniel, I think, again, bueno, nada más, ojalá todos están capturando bien en español algunos de estos puntos claves de cómo es la ley en los Estados Unidos, las facultades de solamente tomar los activos de alguien, por ejemplo, en una cuenta en los Estados Unidos, sí se puede tener el fondo o el base del argumento de un fraude. No tiene que probarlo en un juicio. Es importante que no tiene que probar, nada más tiene que decir, basado en estos hechos que tenemos en nuestro caso, podemos demostrar que existía un fraude para ya en un proceso ex parte, sin la participación del otro parte, tomar los activos. Este punto es tan importante para entender, por favor, because I think, Daniel, that asset forfeiture concept is not something that is existing in Mexico, but to explain how asset forfeiture is not just criminal, there's both a criminal provision, if I'm not mistaken, that's 982, and then the civil, which is the 981, and then the 983 code section, which talks about the proof of what government has to, what your office has to do to prove the fraud occurred, as you've been explaining. I think that's important for us to understand. Those mechanisms, criminal, civil, asset forfeiture. We've got, of course, administrative asset forfeiture. I've dealt with the civil and the administrative, never criminal, but explain, it's a powerful tool the government has.
Very powerful tool. It's important, I think, to sort of just take a step back and understand what the policy is, why the U.S. government thinks that or conceives of the forfeiture tools as important. They consider it a tool to deter, disrupt, and dismantle criminal enterprises and denying them the instruments and proceeds of criminal activity. Pretty impressive the way they state it, but that's exactly true. The other reason why is to have a tool to seize funds in order to ultimately compensate victims should it be a crime that has victims. So in my example of the conspiring individuals in Mexico who sent $1 million into the United States, if I, as a criminal investigator, was working with IRSCI, one of the things we would do, most likely the first sort of public or overt criminal action, is we would seize the bank account. We would seize the $1 million, and IRSCI would just hold on to it. If the individuals in Mexico were charged with a crime, and they came up and they answered the crime, what we would do is we would charge them with the crime and then allege that that $1 million is subject to forfeiture. The way it would work is the individuals would either plead guilty or we'd go to trial. At the end of the day, if we convicted anyone of the conspiracy to defraud the Mexican government, and we also convinced the jury that that $1 million were the proceeds of that fraud or were otherwise property involved in that fraud, or involved in money laundering, whatever the charge may be, that money gets forfeited. It turns into the United States' property. That's all forfeiture means. At trial, our burden is extremely high. We have to prove to a jury of 12 strangers, proof beyond a reasonable doubt, that these individuals were conducted the fraud and they defrauded people or did the money laundering transactions. At the end of that, we then just go back to the jury and say, is it beyond a preponderance of the evidence, which is like 51%? You know, it's not as high as reasonable doubt. And all they have to say is that by the preponderance of the evidence, there is a nexus between that $1 million and the underlying fraud or money laundering that we just convicted you on. And at that point, there'd be an order to forfeit the money. The converse of that is, let's say these Mexican individuals, and I only use Mexico because I use Mexico. It's not a pejorative. I'm not suggesting that this is the only place where this happens, because it definitely doesn't. But let's say the 5 individuals, after we seized the money, had fled Mexico, went to Tahiti, we couldn't find them, and they had money stashed abroad. They had it all in cryptocurrency, and they were liquid, and they were gone. We would still have the $1 million. And so the question is, well, if you don't have the individuals there to stand trial, how do you forfeit the money? What we would then do is we would proceed with a civil forfeiture action. So the United States government has the ability to still forfeit those funds. And the way we do it is we get to sue the money. So I would file a formal civil complaint, and it would be the United States of America versus $1 million taken from this bank account. and we would have a full civil lawsuit. This is, for those American lawyers, this is the in rem jurisdiction. We have custody of the res, of the property, and we sue it functionally, and we have a civil trial. We do discovery, we can depose witnesses, we can do motions for summary judgment, which is always fun, and you basically tell the court, there is zero doubt, Your Honor, that this property was involved in these crimes, and the United States deserves to now own that property through forfeiture. And again, the basis there, the legal standard of proof on the United States government is relatively low compared to the beyond reasonable doubt. We only need to prove to the court that beyond a preponderance of the evidence, again, 50-50, 51%, that money was involved in the crime, and then the judge will enter an order, say it's forfeited, done.
And in those civil forfeitures, I think a lot of people are very surprised to know about the statute of limitations. Normally we think there's a time that runs and it's going to be done. But explain when in a civil forfeiture, at what point does the statute of limitations even commence under the statute, and how long the period runs after the discovery of the fraud?
So I've never actually had to litigate a statute of limitations issue, but my understanding is that it's 5 years from the crime. So if the transaction that preceded the hypothetical we've been talking about, the $1 million in the United States, from 5 years forward, we would have to bring the forfeiture charge or a criminal action. However, if the fraud was super sophisticated and it was concealed in such a way that we did not discover it for, let's say, 10 years, I believe the statute of limitations would be 2 years from that date of discovery of the fraud, assuming it had been 5 years out. So even if an individual or his enabler, as Joshua mentioned, had done a really good job hiding it and hid it for more than 5 years, that wouldn't mean that we would be precluded from charging it.
And just to be clear, the case law on this that I've read and the way the statute reads, it's from the discovery, not from when the act was committed, but when the government discovers the fraud is when the 5-year statute starts. From at least the reading of the case law, and it's pretty thorough the way the case law reads on this 5-year period from the discovery of the fraud itself. This is for civil asset forfeiture.
Understood. There's also one other issue. I'm sorry, I'm hogging the panel, and I apologize. There's one other way in which we investigate crimes, and we do it through treaties. The United States has dozens, possibly more than 100 treaties with foreign governments where we agree that we will provide mutual and reciprocal legal assistance to each other. When we, the United States, want evidence from Mexico, we can't just send the FBI down there or DEA and start rooting around and dropping subpoenas on banks. We do it through our international office, which is the State Department, and the Department of Justice works with the Mexican government in this instance. And the Mexican government will agree, pursuant to the treaty, to gather that information for us in Mexico and then deliver it back to us through Washington, D.C. One of the tools we have as prosecutors is, because that can often take a very long time, we can go to a court and say, Your Honor, while the Mexican government is doing its own investigation and gathering this evidence for us under the Mutual Legal Assistance Treaty, we want to toll the statute of limitations. And we can toll it for at least, or at most, 3 years. And I do that regularly. I do many MLAT requests. They're called MLATs, that's the acronym. Many MLAT requests to Mexico, and in my 10 years, I have seen Mexico be much, 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 much more responsive in terms of not only what they produce, but the timeliness with which they produce it to the United States government, fulfilling their treaty obligations. So you can imagine we are not limited as investigators to only what happens in the United States. We do have access to what happens in foreign countries, and that partnership is extremely important, and it's also very powerful for us here in the United States.
So I know with that we're pretty much out of time, pero nada más quiero preguntar, licenciado Ambrosio Michel, si tienes un último comentario o observación de cómo está vinculado todo, los dos lados de las leyes, como explicaron estos expertos y junto con el lado mexicano, Ambrosio.
Sí, claro. Muchas gracias. No obstante la diferencia de sistemas jurídicos entre Estados Unidos de América y México, a todas las figuras que han hecho referencia mis distinguidos colegas y compañeros de panel, tengo que reconocer y también advertir a aquellos en los que se ubiquen en todas estas figuras que, por lo que se refiere al nuevo delito al que se referían del wire transfer fraud, en México no existe un delito como tal. Sin embargo, a través de lo que es las reglas de la autoría y la participación, está contemplado que a todas aquellas personas que participen en la planeación, asesoramiento o auxilio de delitos fiscales o de lavado de dinero, también se les aplicará las mismas penas del delito cometido por el autor principal. Esto se conoce en la dogmática como coautoría o bien como complicidad. Incluso recientemente, en el año de 2014, se reformó y adicionó un párrafo al artículo 95 del Código Fiscal de la Federación, en donde expresamente se considera como autores del delito fiscal, como la defraudación, a aquellos asesores, abogados, contadores que hayan participado de cualquier forma para proponer, auxiliar o llevar a cabo mecanismos de simulación para evadir contribuciones.
Excelente.
Asimismo, por lo que se refiere al decomiso y aseguramiento de bienes, tengo que manifestar que en nuestro país también la Fiscalía General de la República está facultada para, con base en el Tratado de Cooperación de Asistencia Jurídica Mutua entre Estados Unidos y México, solicitarle al gobierno de Estados Unidos el aseguramiento de cuentas y bienes para su posterior decomiso como reparación del daño en tratándose de delitos fiscales. De hecho, recientemente, la Unidad de Inteligencia Financiera ha anunciado que ha iniciado acciones similares a las comentadas por mis colegas en los Estados Unidos para adjudicarse bienes de mexicanos que han cometido ilícitos relacionados con casos de corrupción en México.